Senator Watson, can I get you to bless us this for us and get us started? Thank you, sir. Later, number 14, is that you? Got you.
Let's pray. Dear Father, we just thank you this day. We just thank you for all your many blessings. Thank you for allowing us all to be here. Just ask and pray that you just continue to lead and guide us as we direct our state. Just give us discernment and the will to do the right things, and just ask for you to do with our families and our businesses while we're away.
Amen. Amen. All right. We are going to be honored to have Senator Brass with us today, our Rules Chairman. And he's going to be presenting to us, it looks like, SB 215 and LC 365524S. And so we'll turn the speaker. See if that's got you. That should have you on, Senator Brass.
You got me?
We've got you, sir.
Thank you, Mr. Chairman. All right, I bring to you SB 215. For those of you that have been here for more than a year, this bill may look familiar to you. A couple of years ago, we came in, it was already in state law, and there was a process that if you were a state employee or a local government employee, you could request to have your private information removed from public information, and that was done allowed for safety reasons. And so what I did originally was come in and allow. I have a lot of federal employees, specifically federal marshals, U.S. Marshals, and FBI, things like that of that nature in our area, due to our proximity to the airport. And so we came in a couple years ago and added that federal piece so that just for their safety as well. And we've had to come back and tweak it through the last 2 years. And so this is one more tweak. We got a couple of counties that are using a little bit of the language to not do this. And so what we've done essentially, and I've gone to actually the industry that that makes money on public information. They had some concerns, so I actually got some language from them, because really the ultimate goal is to get it off of Q Public. And those of you that don't know, Q Public is you can go on to any counties in Georgia. You can go on to any county's website and you can look up just about anybody's where they live or whatever property they own. So we're simply trying to get this information off of Q Public, because we don't want people to be able to track these folks down and cause harm, because there's no good that's going to come out of looking for these people. So that's simply what we're trying to do. We did add a little bit of language. It should be in there somewhere. On lines 38, I did come in and add having to do with the individual spouse. There are cases where a spouse member may be the listed person on the property. So if that's the case, then that can be removed as well. And a kind of a perfect example of what we saw was during the I don't even know, the domestic terrorism events that happened around the Cop City. We saw some information being published. They went and published where police officers in the city of Atlanta were living, their spouses, taking pictures from Facebook. And I mean, to their credit, they didn't say anything about go track these people down and cause harm. But there's no good reason why that would be done. And so there's plenty of transparency and ways to address these people in public settings, but going after them and their families in their private homes is not proper. And so it's simply a safety measure. The reason for the sub was at the chairman's request, we're adding that this needs to, once the request is put in, that the local county has 30 days of receiving that written request to remove those records. So,
thank you. Senator Brass and Chairman Brass and Rules
Thank
Chairman
you,
Brass.
Chairman.
A great bill. I will tell you that I've had several people come to me that are with Homeland Security and other places where there's been issues and people coming after their families. So I think that's important. I also noted this is that public employees, it looks like even you and I could be removed if we were in danger if we wanted to qualify from that standpoint.
We certainly could. I don't feel in danger at this time, but you never know.
It ain't the end of session
Keep
yet.
dropping bills, and you just never know.
All right. Thank you, sir. Any questions from the committee? Time's right. Yes, sir. Senator Roberts. Whoops. Whoops.
Yeah, I'd like to thank Senator Brass for this legislation. My cell phone's out there, and I get calls on that, but I do have a wife and a child that I'd rather not be harassed the way that I am, which it doesn't bother me because I signed up for it. But, Mr. Chairman, I make a motion to pass.
Have a second. We've got one. I've got one. Just a second down here. Further discussion.
Just I was going to make a quick comment.
Okay, please.
It's a
13.
great bill, Chairman. Do you think you can get this out of the rules?
I got a guy.
Okay, all right, that's good. That's good enough for me.
And a point of personal privilege real quick, Mr. Chairman, if you don't mind. I know Senator Estevez is bringing something very similar in intention, and he and I have both signed each other's bills, and there may be opportunity at some point for us to marry the two, but it's a good bill as well. So I just wanted to go on the record to say that.
Thank you, sir. Thank you. All right. We have a motion, a second. Any other discussion? None? Okay. All in favor, raise your right hand. Okay. Any opposed? Nope. Passes unanimously. Hope you can make it through, sir.
Thank you.
And this is LC 365524S.
Yes, sir.
Very good.
Thank you
Okay.
very much.
Thank you, sir. All right, Senator, come up. It looks like y'all may be married from what I'm hearing from the Rules Chairman.
Tag team.
Okay.
Okay. Great. Thank you so much, Mr. Chairman. And I'm here to talk about SB 176, which is a bill aimed to tackle a very similar issue to Chairman Brass's bill. I like to think of these bills being complementary to each other, and I'll explain that in a few minutes. The intent behind this bill stems from incidents that have happened over the last several years, particularly one that happened in New Jersey where the son of a federal judge, was murdered by someone who went to her house looking for her, but encountered her son and her husband at the home. That law that came from that incident is called Daniel's Law. And it's a federal law that provides for the removal of personally identifiable information by federal judges from federal government websites. However, that current federal law does not protect our state judges, law enforcement officers, public defenders, and prosecuting attorneys from having their private information published and used for purposes of harassment and harm against them. So this bill specifically focuses in on judges, prosecutors, public defenders, and law enforcement officers. And it protects their home phone number, personal cell phone, home address from being made public without their express consent. It prohibits all government agencies from knowingly making that information public. And importantly, this bill gives rise to a cause of action by that person against non-agency entities, such as businesses and individuals, who make that private information public with the specific intent to harass the protected person, or does so with reckless disregard for the potential risk of harm to that protected person. So, for example, if you have someone who is upset with a police officer, is upset with a judge, and is posting their home address and their personal phone number on social media with the intent of people harassing that person, this bill would allow for civil remedy and a misdemeanor against that person. Couple main differences between Chairman Brass's bill and this bill. Chairman Brass's bill provides a mechanism for employees to request the removal of personal information. It's a much broader mechanism. This one specifically focuses in on judges, prosecutors, public defenders, and law enforcement officers. This bill also allows for that civil remedy that Chairman Brass's bill does not. So, as I mentioned before, they can work together in concert with each other to ensure that these important public servants are protected from harassment and potential harm. I have spoken to a couple different organizations and have offered 2 key amendments to this bill to ensure that the consequences are not too broad. One is proposing to remove government issued from line 26. That would have been government issued cell phones. Obviously, if it's government issued, it should be used for the public. So that was not intended to be swept into this law. And the other one is a protection for state and local governmental agencies by adding in specifically the word knowingly, protecting them from frivolous lawsuits. So adding in the language, a state or local government agency shall not knowingly post or publish that personal private information. So those are protections that I believe will help improve this bill and move it forward with its original intent. You might hear some further testimony from public defenders and prosecutors who have supported this bill due to their concerns for their safety. We've also heard from sheriffs about their concerns, and I know several of you have your own concerns that you've heard from constituents who are judges, law enforcement officers, prosecutors, and public defenders. But I am asking for favorable passage of this bill out of committee, and happy to take any questions.
Okay, thank you. We're going to take your amendment, and this will ultimately be a substitute when it comes out with those changes made in it from that standpoint. Any questions on the committee as far as addressing the bill? Anybody? Ready? Okay, we've got some public comment. Why don't we let them,
Okay.
hold on, we got one. Hang on. Somebody. Oops. Elena? Okay, wait, no. Okay. We've got some people who want to speak to it, and then we'll call you back up, okay? Let's see. First one, Richard Griffith. All right. How are you doing?
Doing great.
Very
Thank
good.
you for allowing us to speak. My name is Richard Griffiths. I'm a volunteer board member with the Georgia First Amendment Foundation. With me is Leslie Gaither with the law firm Kilpatrick Townsend, who's also a member of the foundation. We at the Georgia First Amendment Foundation spend much of our time working for open government and transparent government in Georgia, both at the local and at the state level, providing training to the public, to journalists, to public officials about the Open Meeting and Open Records Acts. And right now our organization is very worried about unintended consequences of both SB 215 and SB 176. In 2020, as the senator mentioned, New Jersey's legislature passed what became known as Daniels Law. It was designed to prohibit the disclosure of personally identifiable information for retired and current law enforcement, judges, prosecutors and their families. Unfortunately, the well-intentioned law, and I know both of these laws being proposed are very well-intentioned, the well-intentioned law in New Jersey turned into a bit of a train wreck, creating chaos, making all kinds of public records effectively inaccessible. Agencies across the state shut down databases for fear of inadvertently disclosing information about those in the protected class. And it's taken about 3 years to clean up the mess. Just a few weeks ago, the New Jersey legislature passed another bill to create and budget for a new state agency, the Office of Information Privacy. That office will now manage the extraordinary complexity of determining eligibility and notifying state agencies and local governments about who should be redacted from government databases, and making sure covered persons also know the downside that they are, in New Jersey anyway, while redacted, prohibited from sale or purchase of property, participation in public petitions, because there's no way to verify individuals, notification and participation in class action settlements, and legal notifications that may have bearing on their lives. We are concerned that Senate Bills 215 and 176 could create similar unintended consequences to what New Jersey experienced. You know, as SB 176 is written, and I must admit I haven't seen the substitute beyond what I heard here, we're worried that municipalities, counties, and businesses will be concerned that accidental disclosure will result in criminal prosecution or civil action, and will therefore just simply shut down access to their databases. You know, land ownership and property tax records could quickly not be fully provided for fear of exposing a judge or a public defender's personal information. And records that can now be quickly provided could take weeks to release because of the need to cross-check against the names of covered individuals. And then there's the cost of scrubbing the databases. Who will pay that cost? Again, cash-strapped local governments may decide it's cheaper and simply less risky to just take it offline. SB 215 has vast sweep. There are, right now, according to the Bureau of Labor Statistics, about 700,000 current government employees in Georgia who'd be eligible for redaction. The bill is written in such a way that if I've ever served federal, state, or local government, I can have my personal details removed from public records with no requirement for cause, and the scrubbing could be forever. Would this bill mean effectively that all veterans would qualify? They were public employees, served their country bravely. Would they therefore fall under the auspices of this bill? It's not clear from the legislation that's being proposed. Would a DFACS intern in 2015 be eligible to have their records scrubbed? The way SB 215 is written likely means the public will be unable to determine if a public employee is paying their fair share of property taxes, or whether they're getting a sweetheart deal because their names would be scrubbed or their addresses will be scrubbed from property tax rolls. Sale of land and property involving government employees will become enormously complicated and potentially very opaque. Instead of being exposed and shamed, the mayor of a city could simply go on with impunity, not paying the water bills on the property he and his family owns. And we know that that was happening in a large city near us. A slumlord who once served as a municipal building inspector could become effectively untraceable and unaccountable. So will it be possible to check that an official running for office is living in the district of the office he or she seeks? And SB 176 means that when senators, we come to the next election cycle and want to send a constituent mailing, you could have trouble getting the voter rolls that would allow you to reach your constituents because some may be judges or law enforcement officers, police officers, prosecutors, or other public employees. And the Secretary of State might fear that releasing the entire database could be a problem because of that. Now, admittedly, the Georgia Open Records Act already provides broad protection to public employees' personal information and records that specifically identify public employees in their jobs, titles, or offices. But neither of these bills will prevent information already commercially online and available from other states from being disseminated in Georgia. Look, we know these bills are well-intentioned. We know that there are potential problems here. But we do not believe that these bills as written will solve these problems without potentially creating chaos. And given the lack of time in the remainder of this session and the potential substantial impact of these bills, we respectfully urge this committee to table them, or at least take a breath and think about it over the next months with the constituencies that would be potentially profoundly affected by this bill, such that the core issues of security, legitimate, can be balanced with the legitimate needs of the public for open records. And we stand ready to work with you on that effort. And I know that there will be other organizations that would be happy to step up and work with you.
Thank you, sir. And what organization are you with?
The Georgia First Amendment Foundation. It's a nonpartisan nonprofit.
Nonpartisan 501c3?
Yes, sir.
It is a C3, is that
Yes.
correct?
Yeah.
Georgia,
Georgia First Amendment Foundation.
okay. Have you had an opportunity to look at the amendments offered by the author of the bill?
We have not seen the latest amendments.
Okay. And so, as you started talking, I guess a part of your primary concern is if a citizen wants to find out about the nefarious conduct of public officials, that this may shield those public officials
That is
from
a concern.
Or it seemed to be a pretty heavy concern in part of this, and do you feel that by doing this we're basically shielding individuals? Because I did hear you say that a lot of the information that can be gathered through other means as opposed through, say, an open records request.
Well, our concern is that for fear of running afoul of the laws, that larger databases will be taken offline, because these are all parts of large data sets. They're not individual records in a filing cabinet or the electronic version of a filing cabinet. They're big databases. that must be
I understand that,
managed.
but there is redaction and other things so that when somebody asks for something, they're very specific. And I think Georgia open record laws are extremely specific, down to the lowest paid individual that is qualified to pull that information, as far as the time invested into pulling that information. And I know many hours through law enforcement side, many hours are spent redacting personal information such as social security numbers and other identifiable, information that can be used. So your concern is that
The redactions will result in A, much slower response on the Open Records Act, and B, that the breadth and the concern about the penalties will result in agencies simply taking their records offline and not making them available.
Well, wouldn't taking the records offline, wouldn't that violate Georgia's Open Records Act?
If that's the question. You're a lawyer, I suspect.
No, sir.
I'm not a lawyer either.
And listen, even though I should be insulted by that, I'm not.
Sorry.
Sir.
That's a fair point.
I'm a state senator. I'm not an attorney. That's my smart friend next to me. But
I think our concern is that going in the face of criminal penalties, that agencies will choose not to follow through, as happened in New Jersey. It was a big issue.
Yes, sir. And I've looked at what happened in New Jersey, and as far as chaos, I'm not sure if I would classify it as chaos. I think there were some issues, and I think those were straightened out. But I do appreciate your time. Thank you.
Excuse me, one more outside Robert Smith. Robert Smith. Robert Smith. Going once, going twice. Robert Smith not here. No, okay, don't.
He's checking, I think. Has he been redacted?
He's not, he's been redacted, right, you're correct. Don't see him, okay. Okay, he had signed up as far as that. All right. Why don't you, Senator Espa, step back up, and you may want to make comments about, specifically, we've already talked about our amendment. And,
Yeah, if I can, thank you, Mr. Chairman. And I appreciate the folks from the First Amendment Foundation coming up to speak about their concerns. And those are very much concerns that I had in drafting the bill, which is why I made sure to be very thoughtful about ensuring that state agencies or local agencies were not penalized by disclosing information. Remember, this bill prohibits, with the amendment, prohibits state agencies from knowingly doing it. So this bill will hopefully encourage those state and local agencies to redact certain information, keeping it accessible, but redacting information that would allow someone to come directly to the home of a judge. The only remedy that a judge or a prosecutor or law enforcement officer can seek against a state agency is an injunction, essentially a court injunction saying, take my information off. That would be an extreme circumstance because most state and local agencies would remove that information proactively upon request, which is why Senator Brass's bill is complementary to this bill. As it relates to private citizens, it's exactly why I added the intent language in here, because accidental disclosure is very different from posting information with the intent to harass one of these public officials. I worked with private businesses, with data brokers, to ensure that what we saw in New Jersey does not happen here. With that intent language, it exempts a lot of the activity that we see from private companies where they are selling or reselling information using, and oftentimes in cooperation with, local government. And in my conversations with some of those larger data brokers, they feel comfortable with the language because it specifies that there has to be some malintent behind the publishing of this information. The last thing that I'll say is that this bill, I know 215 is a much broader bill. This bill specifically, 176, is specific to certain individuals: judges, police officers, prosecutors, public defenders, people who are often in some very charged, hostile situations and need to be protected. Obviously, if there are concerns that go beyond what's in the statute, the federal Daniels Law, for example, has an exemption for the press. I don't necessarily think it's necessary here because of our Open Records Act protections, but there are ways to address First Amendment concerns to ensure that the public continues to have access to information. I think this will help spur the movement towards redacting more information that should be redacted in the first place, particularly for these individuals.
We have your amendment here that you gave it, and this is the amendment to SB 176, which is LC 442246, and you're going to, by deleting the word "or government issued" from line 26, and by deleting B1 from lines 33 through 35, and replacing with a state or local government agency shall not knowingly post or publish on the internet or repost or republish or otherwise make available the personally identifiable information of a judge, law enforcement officer, prosecuting attorney, or public defender without his or her express permission. And that is the amendment that will ultimately be a substitute, is what we're going to make that onto your bill from that standpoint, which will be the LC 442246, but it will get, I believe, another an additional number, additional change number. Oh, I'm sorry. Written permission. I thought I said written permission. Okay, but it does require that. What's the? I guess any other questions? Pleasure of the committee. Senator Robertson. Hold on. You're 12. Are you 12?
I'll yield to the
Are you 12?
I'm 12.
12. Okay.
Make a
You're
motion
on.
do pass, Mr. Chairman.
Do you pass from Senator Parrott? Oh,
Right,
well,
that's why I got the motion to do pass, so we
Motion
can
to
move
do
on to
pass.
the amendments.
on the amendment. Okay. Second on the amendment.
Well, I think, don't we need to do a motion before we take up the amendments?
Right. Okay.
So that's why I was moving us along in that direction, Mr. Chairman.
Okay. Your second, so Senator Roberts. Okay. Questions on that? None?
I'd like to make a motion to adopt this amendment in front of us that you just recently read in its entirety, Mr. Chairman.
Okay. Have a motion to accept the amendment as read. Okay. Have a second. Second from Senator Say. Any? See?
See, right, see, senor.
Okay. Any other remarks before we pass? Okay. All in favor, raise your hand, right hand. Okay. I'll pass. Okay. That's done on the amendments. So that amendment goes to our bill, which is LC 442246. Now we need to vote on the amendment, correct?
Just voted on the amendment. You're voting on the
What's that?
Just voted on the amendment. Now you're going to vote on
Yeah, that's what we're voting on the bill now, as amended with the amendment. And do we have a motion on that?
Motion do pass.
Motion do pass from Senator Roberts. Second. Senator Merritt. Okay. 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 Didn't know that. Okay. Any other questions? All in favor, raise your right hand. Okay. All opposed? None? Okay. Pass unanimous. You just have to get by the rules chairman.
Chairman.
But I have a feeling he talked about marriage, so I don't know what that means.
I think like him, I know a guy.
You know a
I
guy.
know a guy.
Very good.
Thank you.
Okay. This is LC 442246, passed by substitute, and then they'll get that corrected and done. Okay? Thank you. Appreciate that.